Good morning, Mr. Karatinos and Ms. Lalu Amin. Mr. Karatinos, are you the only one that's going to be arguing for the appellant?
Yes, sir.
Very good. Then we are ready when you are.
May it please the court and counsel, Ted Karatinos for the appellants, Mr. Paulton and Ms. Stowers. This appeal involves a pure issue of law. We ask the court to reverse dismissal of Paulton and Stowers' active negligence claims because we believe the trial court's dismissal was based on a distinguishable case, Clooney versus Geating, issued by this court in 1977. The issue turns upon procedural history, Your Honors. This is a 2014 collision in St. Petersburg between a tractor trailer and my client's car. It started off as a 2-count complaint, vicarious liability against the commercial motor carrier, H&H Ferguson's, and auto negligence, count 2, against the driver of the tractor trailer, Mr. Thomas Barber. In depositions of Mr. Barber and the owner of the company, we learned about some prior DUIs and driving history and violations of the federal motor carrier safety regulations. So we moved to amend the complaint to add claims for negligent hiring, negligent retention, and negligent entrustment of the tractor trailer by the company to Mr. Barber. The trial court then granted our motion to amend, entered a court order. The first amended complaints were filed by Mr. Paulton and Ms. Stowers, and the case proceeded through discovery until shortly before a final pretrial conference. We had a hearing before the court on a motion to dismiss the active negligence claims based on this court's decision in Clooney versus Geating. Between the time of that motion to dismiss and the hearing, Mr. Paulton and Ms. Stowers dropped their claims of vicarious liability. And when the hearing was called, the only remaining claims before the court against the commercial motor carrier were the active negligence claims. We were somewhat surprised at that point that the defense proceeded to argue Clooney versus Geating because we felt the case was moot since the vicarious liability counts had been dropped. As your honors well know, Clooney versus Geating is based on the proposition that if the plaintiff pleads both vicarious liability and active negligence in the complaint against the commercial motor carrier, both of those claims, concurrent theories of recovery, as Clooney states, cannot proceed to trial in front of the jury based on an evidentiary concern. Well, we felt that when we dropped the vicarious liability claims, there were no alternative theories of recovery at that point. And so therefore the Clooney case became inapposite and the motion to dismiss was moot. And that's precisely what we argued to the trial court. But for whatever reason, the trial court decided to rely on Clooney.
I think in fairness to the trial court, maybe part of the reason why that it was relying upon Clooney is it was reading some of the language in Clooney to conclude that the evidentiary concern that you touched upon, which is the ability to present all of this prior driving history, is still present in an active negligence claim that's being heard by the same jury when ordinarily that evidence would be inadmissible as to the active negligence component of their adjudication. So it's the exact same concern, and in fact, Clooney calls out that concern.
Agreed, Judge, but that's a concern at trial. On a motion to dismiss, we're not at the trial stage.
So that's a fair point. Did you all agree to maybe bifurcate the case?
Well, it was not discussed, Judge, but certainly we could bifurcate the case you decide how to apply Clooney, Judge. But
I'm asking what happened before the trial court. If that issue anybody ever ran that up the flag? Well, hey, why don't we have the jury decide issue of active negligence in a bifurcated fashion, and then we can proceed from there.
We already had liability and damages bifurcated, Judge, so I don't see where that would be an issue to bifurcate the active negligence from the auto negligence of Mr. Barber, I don't see that would be an issue.
So this
But-
was going to be a bifurcated trial anyway?
Yeah, on liability and damages, Judge.
Okay,
That was a
but you would
pretrial
agree
ruling.
with me that your amended complaints still, even the amended complaints, the operative complaints contained vicarious liability allegations because you're alleging Barber acted within the course and scope of his employment, correct?
That's correct, but then we
Okay,
dropped
so
the,
then let me ask this. By adding negligent hiring and retention, how are you imposing additional liability on H and H without moving to add a claim for punitives? How are you adding additional liability?
we didn't add additional liability, Judge. We didn't. And so until we dropped the vicarious liability claim, Clooney was on point. We couldn't proceed to trial on both vicarious liability and active negligence. We understood that under Clooney. There was no additional liability. We agree with you, Judge. But once we drop the vicarious liability, there's no alternative theory of recovery at that point. Clooney becomes an apposite, and the additional liability argument is a red herring because the only liability at that point is active negligence.
Well, it's not a red herring if you're proceeding under a separate cause of action for negligent hiring. I think Judge Sleet's point is what additional liability would be in play under that theory that you wanted to run under, aside from the active negligence liability? Because if there's none, then this really does look like you're just trying to end run and get some damaging evidence before the jury that you otherwise couldn't get.
No, the reason we wanted to go forward only on the active negligence count is a comparative negligence point, Judge. We wanted under 768.81 to be able to compare fault between two defendants and the plaintiff rather than one defendant and the plaintiff. It had nothing to do with evidence. So it was a tactical decision to have the fault compared between three parties under 768.81 subsection 3 rather than two parties. And that was the reason for dropping the vicarious liability claim. And yeah, the word additional modifying liability, there is no additional liability. The alternative theory of recovery is dropped.
Let me interrupt with that. In terms of any claim for comparative, what differential existed between the employer and the employee that would give rise to any other damages beyond what was already covered? And I think your answer is none, that the damages are the same no matter what.
That's right, Judge. That's right. And Clooney would apply.
So the question, I guess, at that point is, what is the distinction between the potential liability for the employer versus the employee when you're seeking the exact same damages? The employer admitted that it was liable for the conduct of the driver, and it admitted that the driver was acting within the course and scope of employment.
You're right. Your analysis is correct, Judge. I see where you're going, but we're not claiming the exact same damages once the vicarious.
Wait. You just said you are. You just said you are claiming the exact same damages. There's no differential.
There's no differential from a substantive standpoint, but from a procedural standpoint, there is, because there's no alternative claim for recovery.
Your client would be entitled to 100% of its damages, assuming there is no fault on the part of your client, correct?
You're right, yes.
So you're saying that the comparative issue that you're looking for is to allocate damages between the employer and the employee, correct?
And the plaintiff, yes.
Well, but let's assume for the sake of argument that the plaintiff has no comparative.
Fine, okay.
So you're saying that there should be an allocation between the employer and the employee, correct?
Yes, sir, yes.
But the employer and the employee are already fully liable for the total amount of damages.
Not once the vicarious liability count is voluntarily dismissed, they're not.
Based on
There's
what,
no alternative theory of recovery at that point, Judge.
but that was a tactical decision that you had made, right?
Well, of course it is, because the plaintiff is the master of his or her complaint. Of course it was a tactical decision.
Yeah, the plaintiff's the master of pleadings, but until you get to trial, you're not. But see, here's the point. I understand the 5th District does not like Clooney at all. by virtue of Trevino decision. But show me a case where you can do what you did without a punitive claim, because even Clooney had punitives, as did Trevino, as did other cases, as did most of the cases I've read on negligent retention and hiring. That's where it added additional liability. The bottom line of your case is a negligent theory. I understand what you're doing, but if you're allowed to offer proof of negligent hiring and retention, you're going to get all kinds of evidence in that had absolutely nothing to do with this accident, because you're going to get into past conduct, past maintenance, past this, past that, DUIs in the past, everything. It's all exemplary. So the nature of what you're trying to get in is to seek to recover exemplary damages or punitive damages. But you don't have a punitive damages claim. So every case that I've read includes a punitive damage claim on negligent retention and hiring. So tell me why yours is different.
Ours is different because in those cases, vicarious liability is also pled. In our case, vicarious liability is dropped.
Yeah, but you kept it in the general allegations. You still kept it in your general allegations.
Well, sure, because it's relevant to negligent hiring and retention, Judge, because you have to be within the course and scope of your employment for negligent hiring and retention to apply.
No,
So
you
of
don't.
course-
No, you don't. There's a hundreds of negligent security cases where the security guard murders or rapes somebody. That's not in the course and scope of their employment.
Well, in this case, this guy was hired and he was within the course and scope at the time of the accident.
So that's vicarious.
That's
Well, but
exactly,
vicarious isn't pled.
but that seems to me to be the exact problem, is there is nothing distinct in terms of a damages claim that your client is bringing for the liability of the employer. And you've acknowledged today that there are no separate damages as a result of the conduct of the employer, right?
But there are no alternative. That's right, Judge. But there are no alternative damages once the vicarious liability claim is dropped. The Clooney case rests on the idea that there's an alternative theory of recovery. In this case, there is no alternative theory of recovery.
Well, there is an alternative, right? There is an alternative theory, but you elected not to pursue it.
Well, sure, but once that we elect not to pursue it, there's no overlapping damage.
And in fact, you had pursued it, but you dropped it again for what appears to be strategic reasons that may not have been good reasons with hindsight.
Well, I think they are good reasons in the sense of the comparative fault statute. But Clooney, and you decide whether Clooney applies. Look, who am I to say? It's your decision. But the way I read,
We appreciate your acknowledging that. But the bottom line is, this is your chance to argue how we should distinguish it.
well, the
What
way,
I say is that we have dropped the direct negligence claim against the driver. Therefore, no alternative theory. So Clooney should be distinguished on that basis. Is that in a nutshell your position?
that's the position, Judge. You hit the nail on the head.
Okay, well, you didn't ask to reserve time. You're just over the 5-minute mark. Do you want to reserve the 5, or you can keep going? It's up to you.
I'll reserve, Judge. Thank you.
Very good. Thank you very much. Ms. Lalu,
Good morning, and may it please the court. Sarah Lalu Amin on behalf of the Appellees, Thomas Barber and H&H Ferguson's Contracting, here in this appeal on behalf of H&H Ferguson's Contracting. I want to start by really honing in on the narrow issue before this court, and I think everyone understands. The appellants argue that whether their status as masters of their complaint allows them to avoid Clooney by selectively pleading around it. Under Clooney, where vicarious liability exists, a plaintiff can't bring a claim for negligent hiring, retention, or supervision, because as this court has noted, the damages are exactly the same. And the only difference is the introduction of driving history evidence that unduly prejudices the defense. There are exceptions to Clooney, but none of them applied here, and the plaintiffs haven't argued otherwise. Rather, they claim that they can disregard Clooney because 1, the general rule of alternative pleading trumps it, and 2, by voluntarily dismissing their vicarious liability claims, they can unilaterally render Clooney irrelevant. And it appears that they're conceding issue 1 as they did in the trial court, where they stated on the record, if we had kept the vicarious liability counts in this lawsuit, Judge, Mr. Wood and the defense would be entirely correct, and Clooney would be directly on point, and Your Honor would have to dismiss the active negligence counts. Now, the plaintiffs argue in their reply brief that this isn't a concession because they went on to argue that by dismissing their vicarious liability claims, they've rendered Clooney irrelevant. But this most certainly is a concession as to their alternative pleading argument. So that argument's gone. But regardless, between arguments 1 and 2 that they've raised, the analysis is really the same. Clooney isn't a case about technicalities. It's a case about prejudice and avoiding exposing the defense to that prejudice unless it's unavoidable in order to allow the plaintiff to recover in full. Clooney is conservative in its ruling in that it doesn't bar active negligence claims on a blanket basis. Some minority jurisdictions do that. Instead, it recognizes well-reasoned exceptions to the rule, and it did that on the front end when it stated its rule in the first place. Again, the plaintiffs don't argue any of those exceptions here. And I want to briefly respond to the argument in the reply brief that my client somehow didn't preserve an argument against alternative claims. Again, it's really the plaintiff that abandoned this argument at the dismissal hearing, but moreover, there's no requirement, and the plaintiff has cited none, that leave to amend, which is liberally granted, has to be challenged in order to preserve later arguments against failure to state a claim. And to the extent the plaintiff suggests my client had to appeal leave to amend or denial of their earlier motions to dismiss, of course, they didn't have to do that. They couldn't do that, and they certainly didn't need to cross appeal those prior rulings in order to defend this appeal here today. So there's no preservation issue here for H&H, the appellee in this case.
Ms. Lalou, one question. Had the plaintiff sued only the employer from the beginning, and had they not sued the employee, is your position the same, that even under that circumstance, the Clooney rationale would apply, the driving record of the driver and other information relevant to the hiring would be irrelevant to the case?
Your Honor, there you're getting at a cleaner kind of issue than what's before this court, and I understand, that inquiry. It certainly would get closer to a novel issue there, because that would have been the only claim that was raised, and we see that in cases that involve exceptions to Clooney. So certainly that can happen, but that doesn't happen here because the claims, as the plaintiffs have acknowledged, those claims subsume vicarious liability. So where you have a case like this, where the claims, as your honors have noted, actually subsume vicarious liability, we're not talking about negligent security. We're not talking about cases where the driver, for whatever reason, isn't liable. We've seen cases like that. They're cited in the briefs where, for example, a driver wasn't liable due to interspousal immunity that applied at the time. So there could be an independent case against the employer. Those cases do exist. This isn't one of those cases.
So it seems to me then, to be consistent, your argument would be that absent some damage claim, separate and distinct from the driver's negligence, that even if the plaintiff had sued just the employer, it sounds like your position would still be, you can't get into some of the peripheral issues because there's no separate damage.
That's correct. There's no separate damage. And so there's no need to parade that prejudicial evidence before a jury. So typically, as Judge Sleet, you noted, most of these cases do come up in the punitive damages context. And that was Clooney, that was other cases that have been cited to this court. Clooney announced the general rule that applies in these cases, that justice requires that a caveat be imposed on the use of any of these theories, negligent hiring, employment, entrustment, where these theories impose no additional liability. To your point, Judge Silberman, in a motor vehicle accident case, a trial court should not allow them to be presented to the jury. The reason for this is a very practical one. Under these theories, the past driving record of the driver will of necessity be before the jury, so the culpability of the entrusting party can be determined. As we said in Dade County v. Carucci, ordinarily the evidence of a defendant's past driving record should not be made part of the jury's considerations. The court noted that the active negligence claims impose no additional liability because the owner of the vehicle in that case didn't deny ownership or permissive use, just like we didn't deny it here, we admitted it. The court held that since the stricken counts impose no additional liability, but merely allege a concurrent theory of recovery. And that's really what it's all about, is a concurrent theory of recovery. The desirability of allowing these theories is outweighed by the prejudice to the defendants. This court recognizes that there can be situations, and we've talked about those, that can give rise to additional liability. So this isn't one of those cases. In the Dade County v. Carucci case that this court cited in Clooney for the proposition that driving history evidence is prejudicial, the trial court granted a new trial, finding that its admission of that evidence unduly prejudiced the defense. The appellate court affirmed, holding this evidence ordinarily shouldn't be considered by a jury. The court noted that the record indicated that the driving record evidence presented appeared to receive undue attention in that case. And of course it did, it always does. The notion that a limiting instruction can solve this problem is unrealistic. Introduction of the evidence with a limiting instruction should only happen where the additional claims have to go before a jury in order for the plaintiffs to be made whole. But where, like in this case, the prejudice can be avoided altogether without impacting the plaintiff's ability to recover, the law requires the prejudice to be avoided. And that was properly done here. In fact,
Well, I still think that even if you have, I mean, I've done a lot of trucking work. It's been a long time, but I still think if you've got the vicarious liability, you still have a negligent action. The driver's personnel file is discoverable, as is his supervisor, as are the policies and procedures of H&H Trucking. And should you find something that you feel is relevant that leads to admissible evidence, and there's conduct in terms of this training and things like that, that could arguably be admissible, even if you still have just a negligent action. But this case is different, where they're dropping that and they're seeking only the active negligence on the part of H&H. Now, doesn't that open up a can of worms to a whole panacea of past conduct that has nothing to do with this accident?
That's right. That's right. And so the allegations in the first amended complaint, they go on and on about a litany of things that have nothing to do with this accident at all.
So what claims are still pending, since this is a partial final judgment?
So the claim against the driver is still pending.
Okay.
Yes. And I do want to note that the only case that really endorsed the use of a limiting instruction, because that's how they say the prejudice can be curbed, was Dunmore v. Eagle Motor Lines. And that was a complicated case that got even more complicated based on the positions and relief sought by the parties. And I think that's really instructive here, because Judge Silverman, as you noted, this is a strategy. This was a strategy call. And we can't ask the trial court to be responsible for that strategy, or this court to be responsible for that strategy. This court certainly does decide how to apply Clooney, but it can't step in to alter the strategy decisions of the plaintiffs. So in Dunmore, the plaintiff sued the tortfeasor driver and the driver's employer, but the plaintiff also sued another company, Eagle, for negligent entrustment. Eagle wasn't the driver's employer, it had leased the truck. So right up front, there weren't any defendants that were subject to concurrent liability, and the defendant that had vicarious liability was not being subject to an active negligence claim. So they rely on Dunmore, but it's irrelevant right off the top for that point. But it gets even more inapplicable and even more odd. The driver and the employer moved to sever, so their liability could be assessed without the prejudicial evidence of driving history that would be required in the case against Eagle. Eagle joined in the request. So the parties went through the first portion of the trial against the tortfeasors and the vicariously liable employer. Like here, there was the defense of comparative negligence in that case. So there was an apportionment of liability in that first portion, essentially the driver and the plaintiff. Eagle then made a bold argument after agreeing to a severed trial where its liability would be submitted in phase 2. It claimed satisfaction of judgment against the tortfeasor meant it got off scot-free, or at least that the issue of damages was res judicata. The trial court granted summary judgment for Eagle, but the appellate court disagreed. In reversing, the court first noted that Clooney didn't apply because the negligent entrustment claim against Eagle imposed no additional liability on Eagle not otherwise available to the plaintiff under any other legal theory. So this was a case where claims really had to be tried together. And when that's the case, the best accommodation that a judge can make is a limiting instruction. But we know presentation of this evidence, even with a limiting instruction, is still plenty prejudicial. It's just that in cases like Dunmore and also in Trevino, which Judge Sleet you mentioned, it's not unduly prejudicial because it's necessary for the plaintiff to fully recover. The first DCA observed that had the claims been tried together, liability simply would have been apportioned. The court really didn't explore derivative liability issues, which Judge Silverman, you touched on here, but there were more parties at the table, so it was more complicated. But the court noted that since the matters weren't tried together, the plaintiff had a right to have the jury decide whether comparative liability of the plaintiff might be a different ratio as to Eagle, particularly if its negligent entrustment was especially egregious. The court stated, the case now before us exemplifies the problems that can and do result from ordering separate trials of joint tortfeasors in a comparative negligence case. The court held there was no need for severance and that a limiting instruction could have been used to remedy the problem. But finally, the court held, and this is really applicable here, we recognize that both the plaintiff and Eagle may be treated unfairly by the submission of the issues to the jury in this manner. But Eagle insisted on the severance from the driver and vicariously liable employer, and the plaintiff didn't appeal, and both have to live with their respective decisions in this regard. So obviously Dunmore can't offer us guidance here. The facts were distinct, and the unique procedural posture is one that truly confounded the court and probably will never be replicated again. It's certainly not replicated in this case. And this was the same.
I'm going to ask one question going back to what Judge Sleet asked a minute ago. The procedural posture of the case as it currently stands is the appellants have their respective claims for the driver's negligence pending. The vicarious liability of the company as a result of the strategy chosen is now out of the case if we were to affirm. Is that correct?
That's correct.
I just want to make sure I had that recollection correctly. Thank you.
I have a
correct,
question. I have a question just for clarification and edification, because the 5th District in Trevino doesn't think much of Clooney, and they try to make a distinction by the amendment of 324.021 subsection 9 subsection B3, where it appears to expand an employer's liability. Not only is it for the exposure of vicarious liability, but it doesn't apply to limit the owner's direct liability for his or her own negligence. Now, I know Trevino was two parents allowing their son to drive the car recklessly, et cetera, and there were punitive claims pending, which were also awarded by the jury and affirmed. But tell me, does Trevino apply here, because they are alleging an owner's direct liability for their own negligence? So, or is Trevino distinguishable because these are parents and it's not vicarious liability? Tell me.
Yeah, absolutely. So Trevino is another Clooney exception. It's one that didn't exist at the time of Clooney because of the subsequent statutory amendment. But in Trevino, the plaintiff could not recover against the owner to the same extent under vicarious liability and active negligence. And that's because the statute capped vicarious liability. So having an active negligence claim was especially important and necessary in Trevino, because if the active negligence existed, then the liability of the owner would not be capped, because the statute applies only by virtue of ownership. So if there's independent liability, and the statute acknowledges this, if there's separate liability, then the statute doesn't apply and the damages aren't capped. So Trevino is really another example of the punitive damages classes of cases where you have additional damages that are available by virtue of that active negligence claim. And Judge Sleet, I understand you're noting that they don't think much of Clooney over there. It was one judge, and that was in the concurring opinion. It was Judge Sawaya who stated, "This case demonstrates why the decision in Clooney should be abandoned and no longer followed." well, the majority, Judge Jacobus and Judge Orfinger, they applied Clooney, but essentially recognized this exception. And it is another typical exception where you do have additional damages. The plaintiffs have acknowledged here that they do not have additional damages. They are the same damages. So there certainly are exceptions, but again, none of them apply here. I do want to take a quick opportunity to address the issues of attorney's fees pursuant to the defendant's proposals for settlement. As I understand, our request for leave to reply to the opposition to our fee motion was deferred to this panel. Essentially, the argument in opposition is premature. They're claiming that because my client didn't move for fees in the trial court, they can't move for fees here. And they argue this is because the statute indicates that a fee motion has to be filed within 30 days of judgment. But appellate courts are frequently called upon to issue conditional fee orders. And this court has held that failure to timely seek fees in the trial court doesn't preclude a party's ability to seek fees in the appellate court. This is my client's only opportunity to preserve its rights to appellate attorney's fees. So as with any other case that comes up on appeal before it proceeds to a conclusion where fees can actually be assessed, we're simply asking for a conditional ruling here. So, Your Honors, as we've asserted, Clooney is sound law based on sound policy, and it was properly applied here. There's no basis for departing from it. And with that, unless there are any further questions from the bench, I'll conclude by respectfully requesting on behalf of H&H Ferguson's that this court affirm. Thank you.
Very good. Thank you very much. Mr. Karatinos, you've got the 5 minutes reserved.
Your Honors, we relied on the specific language in Clooney when we dropped the count of vicarious liability. It says in Clooney, since the stricken counts impose no additional liability, but merely allege a concurrent theory of recovery. There is no concurrent theory of recovery. There was a concurrent theory of recovery, but once that concurrent theory of recovery was dropped, there was no longer concurrence. There is no additional liability. There is only the liability of active negligence. The concurrent theory of liability was dropped. So there are no overlapping damages. There are no same damages. There is no additional liability. There's only one theory of liability. There is no concurrent theory. The only theory is active negligence. So Clooney does not apply. I can only rely on stare decisis. I'm only as good as the decision I read. And when I read Clooney, that's the way I read it. Now, I'm not the second DCA. You can decide to read it however you want. But I'm the practitioner here in the trial court trying to follow the law. And the way I read it is, if there's a concurrent theory, and I made this concession to the trial court at the hearing on the motion to dismiss, if there's a concurrent theory, Clooney applies. I made that concession.
Counsel, would you agree that in applying a case and in reading a case, you need to read all of the case and all of the holding and not just selected parts?
Well, sure, Judge.
Because it seems like your reliance is just on the one selected part that you're reading without any of the preceding part that talks about why that rule was announced.
So let's talk about the public policy briefly in the last few minutes. This gentleman wouldn't be behind the wheel if he hadn't been hired, if he hadn't been retained, if he hadn't been given the keys. He wouldn't have been there. He wouldn't have been at the accident scene because he wouldn't have been driving. So the public policy is, if you're going to be vicariously liable anyway, don't allow this bad evidence to come in. But if you're not going to be vicariously liable, then the evidence is going to come in. Don't put this guy behind the wheel. There's got to be comparative fault. And
so this is about the evidence.
What's that?
This is about getting that evidence before the jury.
No, this is about comparative fault, Judge. It's about comparing two defendants with the plaintiff rather than one.
Gotcha.
One last question, because you can't deny that Clooney started out with punitive claims. Now, the trial court struck the punitive claims that were added to negligent hiring and retention. And we found in Clooney, given the fact that the punitives were stricken, you're dealing with two simple negligence claims, neither of which add any additional liability. Therefore, they were concurrent theories of liability that are prohibited. I find that to be significant because the punitives were struck. Therefore, they were just basic negligence actions, concurrent, seeking the same type of damage, not imposing any additional liability. Do you
I agree with you, Judge. I agree with you, but here's the problem. Two issues. One, Clooney is a trial case. This is a pleadings case, and the Clooney case and 1.110G alternative pleading must be able to coexist at the pleading stage. And then one of the theories has to be dropped before trial, which is exactly what happened here. So if you follow what the appellee says, then you could never plead without punitive damages a case against the employer like this, both vicarious liability and active negligence. If you follow the appellee's theory, you would never be able to do that. And so Clooney would trump 1.110G, which makes no sense. They have to be able to coexist.
Isn't what you're basically saying right now is the trial court shouldn't have dismissed the active liability claim because you still could present a claim at trial for vicarious liability. The problem, of course, is you knowingly dropped the vicarious liability claim.
Correct.
Okay. All right. Well, that brings us to the conclusion. Thank you both for your presentations today. You will be asked to leave the virtual courtroom, and then we will move on to the final case that's scheduled for the oral argument docket, Sasser versus Florida Fish and